Hi everyone, I'm Andrew Kerr, a disability rights advocate. If you're a person with a disability, a parent of a child with special needs, or just someone fighting for equal access in public schools, especially in Massachusetts, this video is just for you. Today we're diving deep into one of the most powerful tools you have, the interactive process under Title II of the ADA. We'll cover how it ties into Section 504 in the IDEA, why it's stronger than you think, and how a brand new Supreme Court decision from 25 just made it even easier to hold schools accountable. Stick around, this could change everything for your fight. What is the interactive process? Let's start with the basics. The interactive process is a legal requirement under Title II of the Americans with Disabilities Act. It applies to all public entities, like schools, municipalities, and government programs. When a person with a disability or a parent on behalf of their child requests a reasonable modification or an accommodation, the public entity must engage in good faith. Interactive dialogue to figure out what works. This is not optional. Ignoring requests, delaying endlessly, or flat out denying without exploring options, that's often seen as deliberate indifference, a key legal term we'll come back to. The same duty shows up under Section 504 of the Rehabilitation Act, which covers any program getting federal funds, pretty much every public school. And it overlaps beautifully with the IDEA, the Individuals with Disabilities Education Act, for special education. Every disabled person and every parent of a disabled child has the right to use this process to get equal access to education and services. Deliberate indifference, undue burden, and fundamental alteration. Now, let's talk about why denials happen and why they're often illegal. Schools can only deny a reasonable modification if it would cause an undue burden, like a massive financial hardship or a fundamental alteration, completely changing the nature of the program. These are the high bars. They have to prove it, not just claim it. If they deny without engaging interactively or ignore clear needs, that's deliberate indifference, knowing there's a strong risk of discrimination and doing nothing about it. And non-engagement in the interactive process is classic deliberate indifference. Now, why does this matter for revocation or non-granting of accommodations? Because without a proper interactive process, any denial is suspect and opens the door to lawsuits for damages. The game changer, A.J.T. versus Osseo Area Schools. Speaking of lawsuits, let's talk about the massive Supreme Court win from June of 25, A.J.T. versus Osseo Area Schools. This unanimous decision, written by Chief Justice Roberts, struck down the old bad faith or gross misjudgment standard that some courts use in education standard. This standard was nearly impossible to prove. You basically had to show the school was acting maliciously. Now, nationwide for Title II and Section 504 claims in education, the standard is deliberate indifference, the same lower bar used everywhere else under these laws. Schools can be liable for damages if they disregarded a strong likelihood of violating your rights. No need to prove animus or evil intent. Justice Sotomayor, in her concurrence, joined by Justice Jackson, drove this home. Disability discrimination often happens without bad intent, through failure to accommodate, thoughtlessness, or indifference. The laws reach exactly those cases. This is huge for special education under the IDEA overlap. It lowers the bar dramatically, making it way easier to win or settle against schools and municipalities. And if you put specific officials like the ADA Section 504 coordinator on notice through written requests during the interactive process and they still ignore you, that builds deliberate indifference, plus prior notice, which can be used to shred qualified immunity and open personal liability for individuals, on top of the district's official liability. Settlements happen fast when personal pockets are at risk. The interactive process versus public records requests. Now, one big advantage here in Massachusetts, the interactive process has way more teeth than filing public records requests under state law. Public records requests often hit exemptions, privacy, security, deliberate process, and schools can withhold info without much consequence. But federal laws like Title II and Section 504 supersede those state exemptions when it comes to disability accommodations. The interactive process forces disclosure of relevant info and real engagement. No hiding behind state law when federal civil rights are at stake. What can parents request? Real pressure points. So, what can you request through the interactive process to build leverage? Start by writing formally to your school's ADA/Title II or Section 504 coordinator to start to kick off that dialogue. Here are powerful examples drawn from patterns in Massachusetts and First Circuit cases around restraints, IEPs, segregation, and more. Detailed incident reports on any physical restraints, holds, or seclusion involving your child, including who, why, duration, and injuries. Staff training records and certifications for anyone handling restraints, behavioral plans, or special ed services. Spots unqualified staff fast. School-wide data on restraint use, numbers, patterns, demographics to show systemic issues. Full behavior intervention plans, functional behavior assessments, crisis plans, and any notes for your child's IEP or 504 plan. Records on teacher accreditation, IEP, storage, security, spending on special ed services, or any data tied to the potential discrimination. Requesting this forces the school to engage or risk deliberate indifference claims. It uncovers hidden problems and pressures them to grant accommodations or settle before a lawsuit. Parents and disabled individuals. The interactive process is your strongest weapon. Combined with the new A.J.T ruling, it's never been more powerful to demand what you're entitled to. Document everything in writing, engage with that coordinator, and do not back down. If this helped, like, subscribe, and share with other families. Drop questions here in the comments. I'm here to help fight alongside you. Thanks for watching, and let's keep pushing for real equality and pushing for the best education for our children. Thank you.